This is Jeb Butler and Brittany Partridge, lawyers at the Butler Kahn firm, and we're here today to talk about a recent verdict that Ms. Partridge and I went and got in the state court of Henry County, Georgia. It was a verdict for $29.4 million. We had a lot of help doing it. Melody Walker, paralegal of our office, helped immensely, as did Naveen Ramachandrappa, my old buddy and a lawyer at Binder at Mixon and Elmore, Matt Kahn of this firm, and Christy Gilbert of this firm. So a real team effort. But we were really proud of the result. The verdict was $29.4 million once interest and fees are added to the judgment amount. We believe the judgment should end up being just north of $40 million. So I've talked for a while. Let's hear what actually happened, Ms. Partridge.
Okay, so this case involved a minor sexual assault victim. Our client was 13 years old when her and her family were staying at a hotel in Henry County, Georgia, and this hotel decided to hire an employee without investigating this employee whatsoever. They didn't do a background check, they didn't check references, they didn't ask about gaps in his resume, basically didn't ask this guy anything, and they gave him a key to every room in the hotel as a housekeeper. Well, it turned out that had this hotel company run a background check, they would have learned that this employee has a large criminal history that includes violent and sexual offenses. And so as part of this case, we hired a private detective to run a background check for us on this employee. And here we have Exhibit 3, which is an exhibit at trial, which shows the employee, Irion Williams' criminal history from before he ever took this job at the hotel.
So if the hotel had run a background check, is this what they would have gotten?
Yes, they would have seen this type of background check with these offenses on there. And as you can see, there's felony theft by taking, interference with custody of a minor, statutory rape, along with pimping, a pimping conviction in this case, battery, criminal trespass, more battery and criminal trespass, family violence, and also probation violations. So quite a colorful background here.
And Brittany, what would have happened if the hotel had, maybe they ran a different background check, they only saw pimping, and maybe the rest didn't show up? And what if they looked further into pimping? Could they have done that? What would they have found?
Yes, so the hotel absolutely could have looked more into pimping. Court records are public records, and anybody can actually obtain these records. But had they gone to the courthouse or hired somebody to look into these convictions, or even really use the online databases through these court systems, they could have pulled Williams' pimping conviction, which here we have as Exhibit 1, which we used at trial. And as you see, this conviction has a specific term as part of his sentence that he is not allowed to enter the premises of hotels, motels, inns, extended stays, all within Gwinnett County. So this employee's criminal history had specifically prohibited him from even entering the premises of these types of hotels. And then our defendant in this case winds up hiring the guy to work as a hotel housekeeper.
So what about, let's say, find my mouse and I can drive to where I want to be. All right, well, let's take this one. Let's say that the defense or that the hotel had just seen here. It says statutory rape, but this is an arrest. This is not a conviction. What if they're like, well, maybe he was innocent? Could they have looked further into statutory rape?
Yes, again, they absolutely could have online or hiring a private investigator or calling the court system. And we actually pulled it actually looks like a ticket, but the police report from Williams' statutory rape arrest where he admits to having sex with a juvenile while he's an adult. And so, again, the hotel could have looked into this. They chose not to because they didn't even ask Williams if he had a criminal history and didn't bother to run a background check. So
here's the police report. It says, Irion Williams, that's the guy, also disclosed having sexual intercourse with said juvenile.
Yes.
Is that bad?
That's pretty bad, and that's what winds up happening here to our client.
Yeah. So, Brittany's done a good job with the facts. How do we go about proving liability? Well, one of the things we did was early in this case, we took the deposition of the chief operating officer of the defendant, Peach State Hospitality. Defendant was the company that operated the hotel, and they're one of their highest up executives, right under the CEO, is the chief operating officer or COO, who is a fellow named Ricky Rahman. pretty early in this case, Brittany and I knew that this hotel was dirty. We knew what had happened. We knew this guy they hired, Williams, that had sex with a girl who was 13, half his age. And we knew as soon as we got that background check that he never should have been hired. So we took the deposition of their chief operating officer and asked him things like, well, do you admit that you all screwed up here, that you negligently hired this person, that is, that you were negligent when you hired Williams? And the answer is telling. Here's a little video clip of that answer. This will be a video played from his deposition, which is testimony taken outside the courthouse.
I want to ask you about another one of these interrogatories, and specifically it's going to be number 18, again here in Plaintiff's Exhibit 51. And this kind of goes to the core of what we're talking about. You see where it says Peach State Hospitality negligently hired Williams?
Yes, I see that.
And in response, Peach State denied that, right?
Yes, I see where it says defendant denies request number 18.
Do you stand by that answer?
Yes, I do.
So that was in September or October of 2022. And for years and years, until we got right to trial, the defendant never admitted any wrongdoing. As we got closer to trial, they would say, well, maybe we should have run a background check, but didn't admit negligent hiring, didn't admit negligent supervision, didn't admit they failed to keep the premises reasonably safe, which is crazy. I mean, that is an insane way to handle this case, in my opinion. But that is what they did. And so when we got to trial, we also played another little clip from that deposition. Brittany and I believed that it would be clear to the jury that this hotel operating company had done the wrong thing and allowed this 13-year-old girl to get raped. So we also played this clip from the deposition, which showed, in our opinion, sort of the lack of seriousness with which the hotel company approached their error. Let me play that now.
What changes to its policies and procedures has Peach State made to make sure this never happens again?
You say that again?
What changes to its policies and procedures has Peach State made to make sure this never happens again?
I can't speak to those pertaining to any potential changes being made or have not made.
Do you know of any?
Not off the top of my head, no.
So Brittany and I thought, and I believe the jury thought, that Peach State had just, they didn't care. They didn't care what they'd done to this little girl, what they'd done to her family. All they cared about was protecting their bottom line, and had made essentially no changes. It made me mad. I don't think the jurors liked it very much either. So that's essentially the liability case. There's more we could talk about there, but we want to keep this video to a manageable length. Why don't you talk to us about damages?
Yeah, so in any sexual assault case, the damages are hard to really put a fixed number on because while they are very, very serious, there's usually not very many medical expenses associated with them, even potentially for future treatment. Even though counseling can be very expensive, it's a lot of unknown, but we, in this case, hired an expert who is a licensed professional counselor who mostly deals with clients who have been victims of sexual assault. And she was able to talk about her experience, which was, working with these clients who were victims of childhood sexual assault, and also her prior experience working at district attorney's offices and with forensic interview sexual assault centers about what our client's future likely looks like given the damages to her. And in addition to hiring this expert, we also obtained the forensic interview, which is basically an interview that's done at a sexual assault center between a victim and a forensic interviewer. And the forensic interviewer is trying to get, all the evidence that they need for the criminal prosecution, but in a non-leading way. So it's very important that the forensic interview uses these open-ended questions. Our client did have a forensic interview, and we played that for the jury at trial. We also prepared our client for the blame because defense counsel in this case decided that it was going to be blaming our client, claiming that she knew what she was getting herself into, and saying that she wanted all that happened to her with this 26-year-old, even though she was only 13 years old. So there was a lot of preparation work that went into getting our client and also her family ready for defense counsel's tactics. We also got a conservator involved, which a conservator is basically somebody who is a professional who has control of the minor's claim, because in Georgia, a minor cannot bring a claim by themselves. So the conservator will have complete control of that claim and make sure that any money that's recovered on behalf of the child is actually used for her best interests. Mm-hmm. So that means no family members, no friends, and not even the child can really say, well, I want to buy a car tomorrow, or, I want to buy this house in Hawaii. The conservator is going to plan ahead and make sure that that child is taken care of with whatever money the jury decides to award.
And there's a specific way that's done, right? The health, education,
HEM standard, health, education,
maintenance and
support.
Yep.
Yeah.
Yep. So basically the conservator can pay out money if it's for the minor's health or to educate or for their maintenance or support. And what that means is unclear to me. But if you're a professional fiduciary, which our conservator is, she knows all about it. It's the money gets used responsibly.
Yes.
So that's all like phase one of the trial. A lot of folks aren't familiar with this, but sometimes trials get broken into different phases. And this one had two. A long phase one that lasted about 6.5 days, and then a short phase two lasted about half a day. So phase one, we present all the evidence that Brittany and I have been talking about, and the jury returned a verdict after about, an hour and a half?
Just about, yeah.
Okay. And this was their verdict form. They found in favor of the plaintiff here, as you can see, that's us, and for $21 million. They were able to assess fault. They put all the fault on defendant and none on our minor, which is what we asked them to do. That's great. And then here's the end of the form. They said no to punitive damages, no extra money to punish the defendant, which was actually fine because that gets capped at a relatively low amount anyway. But here they said that because the defendant had acted in bad faith and been stubbornly litigious, that the defendant could be made to pay our client's attorney's fees. And that was a pretty big deal. What's that all about, Brittany?
So under the statute OCGA 13611, it allows the plaintiffs or a claimant to recover attorney's fees if the defendant has been stubbornly litigious, caused unnecessary trouble or expense, or acted in bad faith. And in order to prove, we first off had to have the jury find that the defendant actually did act in bad faith and or was stubbornly litigious and caused unnecessary trouble and expense, which the jury did in phase one. So then we had to prove what the actual or reasonable attorney's fees were in this case. And as like every case here at this firm, we take cases on a contingency fee, which means that our clients don't have to pay us because most of the time they can't afford an attorney. But we only recover money if we obtain money on their behalf. And in this case, we had a fee agreement which allowed for, our attorney's fees would become 40% at this point of the trial. So our client would have to pay as our fee 40%. So I actually did a direct examination of Jeb to discuss our fee, our contingency fee agreement, all the work that was done in this case over, it was nearly 3 years of work to justify the attorney's fees that we would collect, that our client would pay us for the work that we did in the case. And the jury did ultimately find that our client was entitled to the full attorney's fees of $8.4 million. And here you have the phase two verdict form where the jury did take about an hour to deliberate on this one for some reason. But, we got a little scared, but they did award our ask, which was the 40% of the $21 million or $8.4 million.
You could do like an opening statement and a closing argument for phase two as well, and mine were super short. We made some arguments, but they were each like 5 minutes, and the closing argument was the favorite conclusion of any I've ever given. It was a 7-day trial. The jurors were ready to go home. They'd had to come back after a weekend because it was 7 business days of trial. And I told them the last thing was, look, y'all write 8.4 million in the blank and let's all go home. It took them 45 minutes or an hour, but they did. So that brings us to the total verdict, as we said at the outset, of 9.4 million. I told you the judgment would likely exceed 40 million. There's a couple reasons for that. One, we sent an offer early in the case for the policy limits, which were lower than this verdict, under the Unliquidated Damages Interest Act, UDIA. And since the defense didn't pay that and the verdict exceeded that amount, then the defense has to pay interest on the amount that we demanded up until the time of the entry of judgment. And so that came to like 1.7 something million dollars, which pushes this total to something like $31 million. On top of that, very early in the case, we sent an offer again for the policy limits under something called Rule 68. And that means that if we end up with a judgment that is 125% of the offered amount or more, then the defense has to pay our attorney's fees, like again. This time the first time was as a compensatory damage. The second time is as a penalty or as a sanction under what was the tort reform package back in 2005. But anyway, based on that second Rule 68 offer, the defense will have to pay our attorney's fees from the time of that offer until the judgment, which we calculate to be 9-point-something million dollars, which should put the total just north of $40 million. It's a good result for a good family, and we're proud to be able to help them out. We thank the jurors and the judge for their patience with the case. It's a result we're proud of.